So this evening he's going to speak to us about Indigenous in justice, sentencing Indigenous offenders in Victoria. As we know, Indigenous Australians are disproportionately represented in Victoria's prisons, and as came through in the Uluru Statement, the Indigenous population are the most incarcerated in the world, which I had not myself really appreciated. So it's long been the case, and of course, it reflects multiple issues, I think, social and political problems, and a wide range of things which I hope you are going to enlarge our awareness of and help us understand this rather difficult and challenging issue. So if you would join with me, please, in welcoming Professor Freiberg. He's going to speak. He said he could speak for about 4 days when I asked him how long he'd like to speak for, but he'll probably confine things to about 35 minutes at this stage, after which we'll have a Q&A session. So those online, if you could put your questions in the chat, and we'll try and alternate between the Zoom audience and those in the library. So many thanks, Professor Freiberg.
Well, thanks very much, and it's a great honour to be invited to come here on a cold night. And I also would like to acknowledge the traditional owners of the land of Baldwin and beyond, wherever it reaches. And thanks all for coming out. I look forward to a engaging discussion on a topic that's engaged me for many, many decades. In fact, I'd like to thank you, in a sense, for allowing me to cast my mind back. In fact, cast it back some 46 years. This is what I like about this particular audience. With my students, cast your mind back to last year, or even a decade. Vietnam War was ancient history. Beatles is classical music. But here, I feel very comfortable talking about things that happened about 50 years ago when I was a young criminologist, and I was working in Canberra in the heady days of the Whitlam government, and Lionel Murphy was Attorney General. It was my first job, very exciting. Had a wonderful mentor, an English woman called Mary Daunton Fear, who'd been working in Australia on sentencing and pioneered the field. And one of our first publications was in a book on criminal justice, which I dusted off to remind myself, and it was called Gumtree Justice, Aborigines of Court. Now, that was an in-joke, for only lawyers will understand it, because there was something called palm tree justice, which was a short way of describing ad hoc legal decision-making. Basically, the judge sits under a tree and makes it up as he or she, in those days he, thinks, not according to legal principles. So in a little in-joke, we called it Gumtree Justice. And so one of the very first things that I did there, and it was in Canberra, in a very young institute, was to write this with my mentor. And this is how we started. It started thus. In the years since the colonisation of Australia, the philosophy underlying policies relating to Aborigines, and we didn't use the term Indigenous peoples or First Nations, this is 50 years ago, the philosophy has fluctuated from that of extermination, segregation, and malevolent neglect to one more recent of assimilation and Europeanisation. Perhaps the most basic criticism of the law, and one which engenders the perception of egregious injustice, is a legal centralist system that is based on the imposition of a system of law that is foreign and uninvited. We went on. It would not be unreasonable to expect that the law and its agencies to be meaningful to the people who are subjected to it, and it would seem that unless this is done, and if the law becomes increasingly removed from what is viewed as justice, it will rely on force for its validity rather than consent. That was nearly 50 years ago. And I think that we probably identified these basic issues that have been with us ever since and before. And we noted and quoted that even then, The available statistics indicate that Aborigines are arrested, held without bail, and incarcerated in numbers disproportionate to their reported representation in the general population. So what we're discussing today, what we see is not new, not new. It has decades, if not centuries, of history. And then, perhaps a little bit too politely, because I was still young and she was English, we said that in the administration of criminal justice, the Aboriginal may receive less than a fair deal. I think she wrote that. That was, how about bloody awful, but less than a fair deal. So I think it was an understatement, and the countless reports and attempts to reform, matters haven't improved. Let me just cite some of the statistics to remind you. In Victoria, the imprisonment rate for ATSI, I'll use that as a shorthand, prisoners was in 2021 was 1,903 per 100,000 of the ATSI population, compared to 139 out of 100,000 of the general population. That is an overrepresentation rate of 14 times more than the non-Aboriginal population. 17% of the prison population is Indigenous. Australia-wide, Indigenous people make up about 2 or 3% of the population, with about 26% of the prison population. 57% of the total Aboriginal female population in Victoria was on remand, and 50% of the male Aboriginal, that is, they haven't been sentenced yet. So these are people held in custody without having gone to trial. They're not under sentence. In Victoria, the rate of Indigenous young people, 10 to 17, in youth detention was 47.4 per 10,000 people, compared to 7.6 of the general population, about 6 times the overrepresentation. In WA, the overrepresentation times is 24 times Indigenous kids. A report that we did on what we called crossover kids going between child protection and the juvenile adult system, found that while 1.6% of Victorians aged 10 to 20 were ATSI people, 18% of children sentenced or diverted into children's court were of ATSI origin. So I think that reinforces what you probably know about the major issues of overrepresentation. I don't think I need to continue to cite endless data. It was in the earlier statement. So, as Jenny said, what lies underneath it? And here I could go for a couple of days, but looking at the overall literature, what we find is that these data, these figures, these tragic numbers are driven by, as many would say, the legacies of colonialism. And if you've travelled to the United States or Canada or South America or read about, you see the legacies of colonialism still playing out in the Indigenous populations, the American Indians. I'm not talking here about Black Americans or brown Americans, American Indians. We see the same kinds of problems of alcohol, drugs, dispossession, being moved from their land, family breakdown. Canada is, I consider them a cousin jurisdiction, but the same problem with the Inuit people there, very similar. And having been a few years ago in South America doing a bit of travel, that certainly in Peru, the Quechua, the Indigenous people, still seething with resentment about the Spanish colonialism of 400 years ago. It's not forgotten, still seething. Other causes that you'll recognise, the dispossession of the land. We talked about it not being ceded. Intergenerational trauma, stolen generations, and you've seen the reports on that. Systemic racism, discriminatory or differential treatment by the criminal justice system, right from policing through to parole, and socio-economic advantage, unemployment, alcohol, drugs. All these are proximate causes, but the deep-rooted causes I've described briefly, I'll come back to. In a very recent and interesting study on the social determinants of justice, 2 academics in this year published data relating to over 2,700 people who were imprisoned in New South Wales. And they found these were the major factors associated with repeated contact with the criminal justice system. They'll all be familiar to you. Out-of-home care, I was looking to cross over kids, child protection, poor school education, being Indigenous, early police contact, unsupported mental health and cognitive disability, drug and alcohol use, homelessness, unstable housing, disadvantaged location, and so on and so on. So all of these, I think, are well known, but again, documented time and time again. And this is a very useful and penetrating study. Now, what was more interesting was their observation as to structural racism and discrimination. And they observed that structural racism and discrimination connect and compound with individual determinants to exacerbate the likelihood of criminalisation and what's been called hyper-incarceration. Criminal legal systems have become the default manager of many Aboriginal and Torres Strait Islander children and adults with disability. Structural racism is a pervasive experience described by Aboriginal and Torres Strait Islander people in contact with the criminal justice system. Intergenerational impacts, trauma, grief, loss, lack of resourcing, and lack of support for community-led and culturally appropriate services, especially for those with mental and cognitive disability. Other minorities are also subject to over-policing, but Indigenous people particularly so. And they said the criminal justice itself, the criminal justice system itself, is a determinant of criminalisation. That is, it is a catalyst for further discrimination and systemic racism, over-surveillance by police, lack of access to well-resourced legal representation, not being granted diversionary options and bail, lack of specialist legal services. They all operate to exacerbate the system, both for victims and for perpetrators. In fact, for many people in that cohort, their first contact with the criminal justice system was as a young person in need of care and protection, or as a victim of crime. So victims can become offenders. The relationship between the two is very close. Prison, as we have argued with us, I had a long argument once with the previous Liberal Attorney General, arguing with statistics that the prisons are criminogenic. That is, they make things worse. He said, no, your data are wrong. I said, yes, we're not wrong. We can tell you it actually exacerbates the situation. So with that background, let me say, well, what can sentencing do to address these issues? I'm not going to talk about the societal responses, which is beyond my brief. That would take another day or so, Jenny. I'm sorry. So you said, let's focus on sentencing. That's what I work on. And I don't want to talk particularly about the degree to which sentencing contributes to the problem of overrepresentation. That is, whether sentencing outcomes differ for Indigenous offenders than they do for non-Indigenous. That is, if there's any racism, bias or prejudice, conscious or unconscious. There are lots of reasons for differences in outcomes, and there are differences, but they can be explained in some ways to do with the nature of offences, because a lot of Indigenous people are convicted of very serious offences. I'm not even talking about public drunkenness and all of those historical problems, but I'm talking about serious offences. Many of them have a long criminal history, and of course, prior convictions will exacerbate your sentence. And response to previous court orders, that is breach of bail, breach of community correction orders, breach of parole, will all militate against being given a community sentence, given you breached it before. And I'll come back to that issue of culturally appropriate sentences. So you say, all right, smarty pants, have there been any ideas for reform? Well, about 1,000. I mean, I look back at some of the files. So the Australian Law Reform Commission wrote a report in 1986 on the recognition of Aboriginal customary law. There was, you'll recall, and I think some hundreds of recommendations, still many not implemented, of the Royal Commission on Aboriginal Deaths in Custody. They're only now going to record deaths in custody as they're reported, not every year. I think the attorney announced that yesterday. And can I just say on the overrepresentation, there were some interesting studies done on Aboriginal deaths in custody. And that Royal Commission, which the research director was one of my mentors, found that while there were quite a large number of Aboriginal deaths in custody, there were also a large number of non-Aboriginal deaths in custody, but the greater number had to do with the overrepresentation of Indigenous people rather than any particular systemic issues, although the Veronica Taylor coroner's inquest, I think, may indicate that may have been a sanguine view. But it has to do with, there are a lot of non-Indigenous people who die in custody, but we don't focus on that. The Law Reform Commission of Western Australia looked at Aboriginal customary law. The New South Wales Sentencing Council in 2009 looked at sentencing Indigenous offenders. The Royal Commission into Institutional Responses to Child Sexual Abuse had a look at some of those issues with Indigenous people in institutions. Human Rights Law Centre looked at ATSI women in 2017. Australian Law Reform Commission added again in 2018 with a report on pathways to justice. The Parliament Victoria, in its inquiry into the criminal justice system in 2022, talked about it. Endless coroners' reports. And I can't even tell you how many articles, submissions, etc., on the top. So there's no lack of ideas, going back decades. Now, I want to move a little bit from the abstract to the particular. I'm going to give you a little challenge here, as I do with my students. I teach sentencing, despite I'm notionally retired, so I've cut down to 6 days a week, so that's okay. I always start my classes at Monash and elsewhere on sentencing with a real, hypothetical, because that gets the students engaged. I want to, when we spend the rest of the week unpacking this, so I call it "You Be the Judge." So here you are, okay, humanists, you be the judge. So try this one. So in May 2020, David enters a vacant house being renovated and stole a guitar, a didgeridoo and a TV. In August, he stole a Mazda 3 from a driveway. In September, the police saw the stolen car parked in the street with stolen number plates, approached the car. He drove off at a fast rate of speed and collided with an unmarked police car. Later that day, he was seen in the stolen car by 2 police officers who approached the car and parked in front of it. And on seeing the police car, he accelerated, ramming into the police car. A second police car arrived, parked behind the stolen car. He reversed the car, slammed into the second car, accelerated back and forth, causing damage to all 3 cars and creating a risk of life to the police officers. So they caught David, because he was between the 2 cars, and charged him, and he pleaded guilty to burglary, maximum penalty 10 years, theft, maximum 10 years, theft of a motor car, because he stole the TV and the jury, 10 years, aggravated intentionally exposing emergency workers, remember the laws about ambulance drivers and police, to risk by driving, 20 years, and that's an offence where it has to be mandatory to impose a jail sentence unless there are substantial and compelling circumstances that are exceptional and rare. Victim impact statements were submitted by 2 of the police officers. Each of them was traumatised by the assault, which had shaken their faith in their community and their confidence in doing their jobs. One of them was on sick leave for stress and anxiety and resigned from the police force. So serious consequences. So what do we know about David? He's 25. His parents are Aboriginal, but he'd never had any connection to country or the Koori community. His upbringing was unstable, violent, early exposure to drug and alcohol abuse. Both his parents were heroin users. His father was physically violent to his mother. And from the age of 10, he drank alcohol heavily, age of 10, and used cannabis. School life was difficult. He had ADHD, learning difficulties, repeated years in primary school, had a teacher's aide from the year 7, left school at the end of year 9, never been in paid employment. At the time of offending, was homeless, was a drug addict using ice daily, abusing prescription medicine. The psychological reports showed exposure to complex developmental trauma, stimulant use disorder, emotional and behavioural dysregulation. Didn't know that word, dysregulation. stemming from exposure to complex developmental trauma, genuine cognitive deficits. He had an IQ of around 70. While they said he didn't have an intellectual disability, acute intoxication from the age of 10 hampered his brain maturation, negatively impacted his ability to learn. The reports recommended stable accommodation and employment. He pleaded guilty. He was remorseful. He's been in custody for 410 days. That is a year and whatever days. He's also recently connected to the Koori community and in jail was doing some artwork with a program. What do we know about his background? Well, 2016, convicted of trespass, got a bond in a German for 12 months. 2017, unlicensed driving using unregistered vehicle, again given a bond. 2017, possessing ammunition without a license, $200 fine. 2019, threats to kill, contravening a family violence intervention order, threats to damage property, sentenced to 117 days imprisonment. He'd already served that, and put on a community correction order for 12 months, that is, do some work in the community. 2020, he breached that, carrying a firearm, recklessly causing injury, stolen goods, drugs, 93 days imprisonment, already time served. 2020, contravening the community order, dishonesty, drug possession, 71 days. He had 64 days served. And on top of that, the judge hearing this was faced with the provision of the Sentencing Act, which said that you can only not impose a jail sentence. So all those in favour of mandatory sentencing, hands up, said there has to be substantial and compelling circumstances. And you recall that came out of all the kerfuffle about people attacking ambulance workers, and now emergency workers covers just about everyone. General deterrence and denunciation are great importance. Personal circumstances, less important. Don't have regard to previous good character or a guilty plea or prospects of rehabilitation or what you do with others, right? Disregard all those, impose a jail sentence. Okay. Easy case. What would you do? I got this case because I was doing a UB the Judge session with judges who came up with this. I mean, that's a reality of what the judges are facing all the time. I mean, we can talk about Aboriginal overrepresentation, we can talk about the problems, but that's the kind of reality that the judges are facing. Enormously complex cases. Anyone want to have a go at, I could ask you what you would give, but that would be embarrassing. I do that with the students, and it ranges from let him off to hang him by the, but
what's the total charge? What's the total amount of charges?
How many charges? There were 10 counts, I think, this time, yeah. So, Mr. Lawyer, I know.
Never practiced criminal law.
No, I know.
Why?
No, I know. And in the UB, the judge, the students range far and wide, and then they say, well, what do you want from us? We've just walked into your class. At the end of the 6 days, we go back again. But what do you reckon? Anyone want to have a go at what you do? Yeah.
Well, no, this is probably more of a question and answer.
No. I'm asking the questions.
No, if it goes to jail,
Yeah.
hopefully you'll get various sorts of rehabilitation.
You hope so.
And stuff
Yeah.
like that.
He's doing an art program and things. Yeah.
So
Yeah.
is there any way you can get all that sort of rehabilitation and training in the community without?
No, they've already given him that. No, he's got to go to jail. Parliament said he's got to go to jail. Mandatory sentencing, that's what the people want. Yeah. Good one. Good try. Yes.
And it's worth pointing out that it's one of the few cases in English common law where there's a reverse onus. Reverse onus is in the law, frankly, a dirty word, a dirty phrase. But this is one of those ones that people really struggle with because of the balance. Yet you have to match up the structure. I'm not making it easier, I'm making it harder, but it is a reverse onus provision, and it's a provision that
It's almost impossible.
hate, struggle with. No one likes them. They're political judgments.
As they hate the mandatory sentencing.
Yeah.
So anyone want to go for 10 years, 5 years, anything? You can't.
I'm going to go 4.5.
4.5 with a non-parole period of
About 410 days.
time served.
I'm going to say Peace in
Okay, anyone else want to buy in? I'm just for fun.
Are they great? I think it's an opportunity.
Yeah.
So instead of bringing in.
Yeah, there's low, medium and high security, but you have to be assessed for all of those. Yeah, yeah.
Does he identify as Edward?
He didn't originally, but he's now connected. Yeah, yeah. Anyway, you're all reluctant to do it, and I know how difficult it is. So the judge was wonderful, and some of these, you read the sentencing remarks, and there are some extraordinarily wonderful judges in the county court. He got 2 years and 4 months with an 18 months non-parole period. Given his background, given the seriousness, given it was mandatory, given the police were victims, and an 18 months non-parole period. So quite generous, I think, in the light. And he'd already served a year or more. So he would have got out fairly soon. I can give you the reference later if you ever want that, but I give that to the students and then we unpack it. So let's have a look at what sentencing has done and what it might do. This is what the topic, I suppose, was. Well, what does the common law say? Well, the common law says we've got lots of purposes, just deserts, specific and general deterrence, rehabilitation, denunciation, protection of the community. And the judge has a lot of factors to take into account. Someone once counted 200 factors taken into account. But basically, it's got to be proportionate. You've got to be fair and compare it to other sentences. You've got to look at the totality of all of the offences, and there were many of them there. Imprisonment is usually regarded as last resort unless it's a mandatory sentencing. You've got to be parsimonious, do as little as necessary to achieve those purposes. Look at all the aggravating and mitigating circumstances, and there were a lot there. So I must say, you don't envy the judge facing that situation, especially when that person has been through the justice system. And to be fair to the courts, they've tried. They adjourned the cases. They gave a community order. And now you've got this case, and the police union is watching and the media are watching. So the common law says that the court can take into account an offender's background of disadvantage, and you can make submissions relying on that, obviously, or commonly provided by a pre-sentence report, which can look at the offender's history, whether they've experienced deprivation, poverty, trauma. All these things affect what's called a person's moral culpability. How responsible are you for your actions? And these can be taken into account irrespective of the offender's Indigenous background. Indigenous people aren't the only ones who've suffered trauma, who've suffered from poverty or the like. Now, the case law is quite interesting because it's developed over recent years. That article back in the 1970s looked at Northern Territory law, about customary law, because there hadn't been much written about it, and looked backwards as to some of the colonial work. But in 1982, in the High Court, in a case of Neil, Justice Brennan, a wonderful judge who became Chief Justice, said, the same sentencing principles are to be applied, of course, in every case, irrespective of the identity of a particular offender or his membership of an ethnic or other group. Now, this is a principle that the courts have hung on to. That is, all people are equal under the law. Well, that's formal equality. Substantively, of course, we know differently. But he said, in imposing the sentences, the courts are bound to take into account, in accordance with those principles, material facts, including those facts which exist only by reason of the offender's membership of an ethnic or other group. So he says all people are equal, but we can take regard to their background. So much is essential to the even administration of justice. So we've got this tension between equal justice and special circumstances, and this plays itself through. Now, a decade later, after the Royal Commission into Aboriginal Deaths in Custody, a wonderful judge, Justice Wood in New South Wales, delivered a judgment in the case called Fernando, which has been used again and again. Now, he was a 48 Aboriginal man, plea of guilty, charged of malicious wounding, stabbing his de facto partner a number of times. He did live in an Aboriginal community in Walgett, in far west New South Wales. Again, low level of education, forcible removed from his family as a child, extensive criminal records, including many with alcohol, and had been consuming alcohol before the stabbing. So he laid out a number of principles, and I don't have time to read them all, but this is the essence of them. Again, stressing, as the law keeps saying, Same sentencing principles apply in every case, irrespective of the identity of the person's ethnic group. But that doesn't mean we should ignore the facts relevant to that group. Can you see the line that they're trying to tread? Aboriginality doesn't necessarily mitigate punishment, but it helps explain it. So we may not treat you more lightly, but we can understand why you're doing it. We can understand that alcohol abuse and violence go hand in hand with Aboriginal communities. They're a very real one, and their cure requires more subtle remedies than the criminal law can provide by way of imprisonment. Coming back, when we're looking at this as a remedy, this is not the answer. Notwithstanding that imprisonment serves as a deterrent in discouraging use of alcohol, the courts, now this is an interesting point, I've had this debate with many people, the courts must be careful in their pursuit of their sentencing policies to not thereby deprive Aboriginals of the protection which is assumed punishment provides. In short, a belief cannot be allowed to go about that serious violence by drunken persons within their society are treated by the law as occurrences of little moment. Now, this is a really important issue. Many of my students and much of the writing will concentrate on what we've just seen, which is the terrible background, social background, colonialism, intergenerational trauma of the offender. But we have to remember that many of the victims are Indigenous women themselves. And as he says there, they need protection as well. So we've got this tension, especially with the victims movement, with the recognition of the rights of victims, that you've got these two competing considerations. Now, whether they're competing or not, I don't know. But the people who are the victims of awful violence, manslaughter, malicious wounding, deserve protection as well within and outside the community. Drunkenness, he said, is not normally excusing or mitigating factor, but the endemic presence of alcohol within the community, Aboriginal community, and grave social difficulties is something we have to recognise. It's not just idiosyncratic. We have to avoid any hint of racism, paternalism, or collective guilt, but we have to understand the particular local setting and subject. Can you see how he's trying to balance all these? In sentencing an Aborigine who's come from a deprived background, otherwise disadvantaged, a lengthy period of imprisonment may be particularly or even unduly harsh because the environment is foreign to many Indigenous people who may be out in the country. So imprisonment is worse for them than it might be for you or me. And we have to understand that full weight, apart from deterrence and punishment, must be given to the competing public interest to rehabilitation and the avoidance of it. So that's your point, that the judge is saying imprisonment is not the answer, but it's so serious I have to do something. On the other hand, I know it's not the answer. Can you see again the terrible dilemmas? Now, the High Court attacked this in 2013. A person, Indigenous person called Bugme, attacked a prison officer with a pool ball, and he got serious injury, partial blindness. Again, the same, I won't read out the whole history, same story. They made 2 points. One is profound childhood deprivation does not diminish with the passage of time. The Court of Appeal in New South Wales, oh no, get over it. This happened years ago, get over it. They said, no, this will last forever. But in sentencing Aboriginal offenders, we don't take their Aboriginality into account. We don't take into account the high rate of incarceration. The principle is individualised justice. Everyone is treated the same before the law. Now, this has been the subject of enormous criticism saying the High Court does not recognise the systemic differences in the backgrounds. And many people think it's gone wrong. Later on, they also found that it's contrary to principle that offences by Aboriginal offenders should be viewed systemically as less serious than offences by others. They're not necessarily less responsible. It would be wrong to accept that a victim of violence by an Aboriginal offender is somehow less in need or deserving of protection. Can you see again, this other case called Munda, they're trying to reconcile the fact that somebody's been really seriously harmed with the other issues. So the courts have been have been battling this notion of responsibility and equality with the realization that we're not all equal, that there's a difference between formal equality, as Anatole France said many years ago. All people are entitled to sleep under the bridges of Paris. Not everyone does, and this situation. So can we change it by statute? So that's where the law is at the moment. Can we change it by statute? Well, in some jurisdictions, the courts can consider, among other things, the cultural background of the offender. And the Law Reform Commission said sentencing legislation should provide that when sentencing at sea offenders, courts take into account unique systemic and background factors affecting Aboriginal and Torres Strait Islander people. So it says, let's move beyond the common law. Let's have statute that says you can take it into account. So statute can change. Another recommendation is what are called specialist sentencing reports. They're called Gladue reports after a case in the Supreme Court of Canada. And they are reports prepared with people with links to the Aboriginal community that can put, it's not a pre-sentence report, that is the background. It is explaining to the court the particular situation of that person in their cultural context, so that the court can come up with a sentence that's unique to that person and their culture, and look at their historical and cultural nature. So it's not about you. You still have a pre-sentence report, but the Gladue reports are being trialled in Victoria by VALS, the Aboriginal Legal Service. And what's interesting, they can make a difference. They're used quite extensively. We're trying them in Australia. Some judges are using it now without the special legislative provision that I think is required. Sadly, while it makes a difference in individual cases, it's made no difference to the overall imprisonment rate in Canada, and unlikely to do so here. Law Reform Commission recommended those. We've had Koori courts. Koori courts, you've heard of those. First one in the Magistrates Court in Shepparton in 2002, now in 15 locations. A Children's Koori Court in 2005, County Koori Court 2008. The idea there is that Aboriginal elders or respected people advise the judge on cultural issues relating to the accused or their offending behaviour, but can provide background to the court, explain kinship connections. They're basically aimed at shaming the offender by their own community. But it's still the magistrate or the judge who has the ultimate sentencing responsibility. So it is an idea of peer group pressure. And I've had many of the Koori Court judges speak, and they said, that's been very powerful. The shaming element of Auntie Mary and Uncle Joe, that's really powerful, more than white honkies, saying you've been naughty and doing all this, very remote. There are multiple purposes of those involving people in the sentencing process, increasing their confidence. And the room is set out differently. It's not the judge sitting up high. It's a table there, Indigenous arts, works of art and the like. It's more a conversation, and people can sit around and do that. So the elders can get involved, but they don't sentence. Once again, I think it's a terrific idea, and it's been very useful in connecting people with their communities, providing more culturally appropriate sanctions. But once again, I quoted those figures too. It's made no difference to the overall Indigenous imprisonment rates. So great ideas on an individual, systemically no difference. What else can we do? Well, some colleagues have written an article recently that I'm drawing on, and they said, let's also, given the history of colonialism, Indigenous overrepresentation, and I've set out to you, as they did, all of those factors. We talked about homelessness, we talked about cognitive deficits, lack of education, stolen generation. They said, let's move away from the traditional R&R, risk, needs and response, which is the risk analysis, and try to develop a narrative that builds on the strengths of the community. That is, move away from a deficit approach and try to build on the strengths that inhere in those communities. Deficit narratives, they say, present disadvantage as an inherent quality of being Indigenous, rather than a consequence of colonial oppression and structural forces bearing on Indigenous people. Such presentations deny the truth of history, they say, reinforce colonial ideologies and interventions, and compound intergenerational trauma. So they say, let's focus on assets, the power of community, cultural connectedness and healing. And they talk about the adoption of decolonizing approaches. I'm nearly out of time. The other thing we should try and do is develop culturally appropriate sentences, community sanctions, which involve the community. There are now, I'm not going to try and pronounce it, there's a learning place. I'm not going to explain, I'm not going to try and read it out, but it's run by Aboriginal people in the community and grounded in Aboriginal culture. So those community programs are there, they're appropriate. More broadly, the government here and elsewhere are determined on self-determination based on the UN Declaration of the Rights of Indigenous People, and the government itself is committed to Indigenous self-determination, and they've been suggested that legislative amendments should be in the Sentencing Act. That is, those principles, and they are now embedded in many other pieces of legislation. And now we have the Aboriginal Justice Agreements, and they've been developed, and they're providing advice to the government. This is a voice to Parliament, the Justice Agreements, and monitoring the implementation of the Royal Commission recommendations. And they've been developing those with government, and I've been involved for 3 years on a review of the Sentencing Act, and very close work with the Aboriginal Justice Caucus in Parliament and these organisations. And so this whole emphasis on self-determination throughout legislation is very important. And there's been reports on that. Self-determination, the Aboriginal Caucus, I won't read it out, said it's very important. So finally, yet another report, the Victorian Parliament report, a very good report by now no longer a Member of Parliament, Fiona Patten. I must say, it was extraordinary when I heard about this review. I said, well, they can look at the whole criminal justice system in 6 months, spend a whole lifetime. Actually came up with a bloody good report. And they acknowledged the systemic reform to foster cultural safety and enhance self-determination is required to address the overrepresentation of Aboriginal Victorians. Holistic intervention is required, systemic reform. These reforms are fundamental to improving the health and well-being of Aboriginal Victorians, ensuring substantive equality in society and before the law. And these reforms should be pursued in partnership with Aboriginal communities across the states. Existing agreements be implemented. And finally, there's that concept of justice reinvestment. Let's not spend hundreds of millions on building prisons. Let's spend it on investing in the community rehabilitation. So I went back and said, well, what did this young lawyer with his mentor write and conclude in 1977? And this is what we wrote. Australia is by no means the only country faced with the dilemma of reconciling the existence of a centralist legal system with the fact of a pluralist society. While it's clear that some modifications can be made to the substantive law and the sentencing process can be used to ameliorate the greater incongruities, the harsher injustices, these reforms may constitute mere tokenism which can serve to prolong rather than reduce injustice, and more fundamental changes may be required. Indeed, this young man concluded, and his mentor, demands for the reassertion of traditional norms and values of Aboriginal culture need not represent Canute-like gestures before the assimilationist tide. The sacrifice of group identity should not be the inevitable price of equality. Not bad for a young radical. Thanks.
So let's move on to questions.
Yes.
I have a question, which I might use to start with. Thank you very much, Professor, for a fine talk. I'm really glad that you ended up with the prospect of prison reform. after all, the judge normally just consigns somebody to prison, and it's out of his hands how that person is treated. And as we know, a lot of times people are just made institutionalized and a lot worse by that time in prison. So my question is, have you noticed any move towards another form of treatment or something that could be used in conjunction with incarceration, namely restitution of talking to the people who were actually victims?
Yeah, it's a good question. Look, since the late 1980s publication of a book called Crime, Shame and Reintegration by one of the world's great scholars, sociologist John Braithwaite, looking at this notion of restorative justice, which has swept the world, although it's not taken deep roots. And they are conferences, meetings between offenders, victims, families, they're not mediation, they're actually discussions between the parties where the victim can explain to the offender the effect of the crime on them, and the offender can try to explain why he or she committed that offence. And that notion that rather than having a third party, a judge, impersonal, in court where, the barrister would prefer never to have the offender speak in case, like Trump, they incriminate themselves or do something terrible. The idea is that crime becomes an interpersonal matter, and that the idea of the family and people around, that shame is one of the strongest forces that we have, as we've discussed with the Curie Court. And that is become extraordinarily popular in many jurisdictions, not just in the criminal justice system. It's used more extensively in the juvenile justice system, used extensively in the ACT, not enough in Victoria in the adult jurisdiction. There have been some experiments, but that is a different paradigm. And so it's not about restitution, although in many cases you can say, well, yes, I'll paint over the graffiti or I'll write you a letter of apology. It's not, it can be pre-sentence, it can be post-sentence. There have been cases where even where the person is in prison for a very long time, and we're talking about murder or manslaughter, that a restorative justice conference can be held, has no effect on the sentence. What it does is provide some resolution for the parties to understand each other. And very important, especially as many offenders lack empathy. I mean, that's a real problem, that they don't understand the consequences of their action. And so that dialogue, that discussion is very important. So I think Curie courts and restorative justice are different models. This is coming back to the book I did with others on non-adversarial justice. I mean, that's about drug courts, it's about Curie courts, it's about all those, trying to move away from the adversarial paradigm, which has led us down the path of more imprisonment and less effectiveness. So I don't know if that answers your question.
Thank you. Thank you.
On the chat.
Is that Stephen, is it?
Well, I was thinking of Vince.
Vince, is that the voice?
Yes.
Oh,
So we should repeat the
yeah.
question for the group.
Question from Vincent Duca. Any comments on how the voice may help address the issues or problems outlined tonight? Is there likely to be consensus outcome?
Next question. I see people have got the yes vote. Look, I don't want to buy into the question of the voice and particularly whether it's going to be effective or not, because I think there's some really major issues. I think where we're up to with the Aboriginal Justice Caucus and the various agreements and the like is a step along the way in Victoria where those voices are heard, because there's a lot of consultation between the government and the Parliamentary Aboriginal Justice Caucus and many, many other groups. So during this period of revision and reform, which is now fallen into a big hole of the Sentencing Act, and you've seen that recommendation by the ALRC about culturally and systemic racism, it's appearing in all sorts of places in Victorian legislation. There's a bill before Parliament now in juvenile justice. I think there is a voice now, and there are major channels of communication between Indigenous voices. VALS is very powerful in this. And there are other groups very much so. So I think the government and most other agencies, we certainly were very conscious on the Sentencing Advisory Council on consulting with Indigenous people. We had a lot of problems. It's quite interesting. We had a lot of problem getting Indigenous people onto the council and staying on the council, because many of the people we wanted were in such demand by every organisation that they tended to have their services called upon. And so we, in fact, were lacking in Indigenous voices, not for lack of trying, but everybody wanted somebody who'd put their hand up. But that was very useful. And can I just say on that, you asked me about regulatory theory. Well, that's another story to do about how governments run. But I do sit on the Regulatory Authority of Health Practitioners. So that's called AHPRA, the Australian Health Practitioner.
I know.
You know, are you a nurse or a doctor?
I'm a doctor.
You're a doctor?
Yes.
Well, I'll look you up. But I'm on the board, and we've just recently had appointed an Indigenous woman, Professor Carmel Parter, and she has made an enormous contribution to an understanding and changes within AHPRA, and I think it will be in all the 15 professions that we regulate, about an understanding of issues of cultural safety and systemic racism. So I think voices are being heard.
It's changing.
Yeah.
Yes.
So I think the voice is a federal constitutional issue. I won't buy into it, but I think, yeah.
Yes. I mean, I feel that it's an educational process as well. I mean, I was concerned about the raising the age debate, that people saw it as a question of numbers, 10 to 12 to 14. What got lost to a very large extent was the complementary need for wraparound services to support people, to prevent them from getting onto that treadmill.
Yeah.
And I mean, there's a bit of discussion about it, but not enough. People can't see, don't have a concept, I think, of how the components fit together. Anyhow, that's enough from me. I think that James may have a question. Is this true? Yes.
I have a proposition.
A proposition.
I've been propositioned many times, but I never accept. Yeah.
So Arie's been very modest, let me just say. Arie's been at the core of this conversation for 35, 40 years. As a young law student in 1992, when the Sentencing Act came into effect, Arie's name is the only name you ever heard, because he was the principal behind it. So this is my proposition in terms of Indigenous. VALS, Victorian Aboriginal Legal Service, in the reform process that was stalled in 2020, and it's the VALS report's online. Just look it up, Google it, read it, because it's a very good summary of what the Indigenous community would like. My proposition is this: the Indigenous people tell us white people, us white fellas, they don't want us to do things for them, they want us to do things with them. Until we change the Sentencing Act, and I think Section 5 is the general suspect in this thing, to include Aboriginality, which is the VALS term, as a culture that must be taken seriously, just as importantly as the 1,000 years of English common law. Until that's changed, and Aboriginality is a concept within the sentencing provisions, will we ever get the keywords today, structural and systemic change?
Look, the ALRC recommended it. I mean, there's probably 1,000 recommendations in all those reports that I mentioned to you. The Pathways to Justice, which was a very good report, almost none of it has been adopted. The Royal Commission into Aboriginal Deaths, I think there were 200 or 300 recommendations. Only about half after 35 years have been adopted. So whether that's systemic racism, a reluctance to, I think, the political forces are changing. The Voice is a good example of, we're getting that. But you can see the difficult political dynamics when you've got Indigenous people on both sides of this. There's no one, my observation is no one Indigenous voice. You know, the communities are very varied. So I'm cautious about that. And I think we have to be open to listen all, and then we have to make our decision. But this notion, and I did set an essay for my students. My students loved this particular example, and many of them, and I'm really pleased, you know, because as a teacher, you can sort of make a difference to people's lives. And a lot of them wrote essays on indigeneity, and I was really pleased by that. And one of them, you know, they come up to me and ask for advice about essays, and I give them essay. I said, tell me what self-determination in sentencing looks like. It's a bloody hard question. What does it actually look like? Is it going to be Aboriginal judges, or is it going to be Gladue reports? Is it going to be Aboriginal parole officers? I mean, what does self-determination? I don't know the answer to that. I mean, you can say, take that into account, but you can see the tension. I mean, I gave you that case. On the one hand, you've got somebody's been murdered, or family violence, or somebody's lost an eye, or a policeman, all of that. And the judge has got victims there, whether Indigenous or not, saying, my life's been ruined by this person. On the other hand, we're saying, but look at the offender. You can look at their background. I'm not saying it's irreconcilable, but it's very, very hard. And just a provision in the Sentencing Act is not going to cure it by saying, well, I do take that into account. On the other hand, if I say, well, off you go into the community and you've just killed somebody, it's bloody hard. Yeah, sorry.
Another question?
Yes, the philosopher's zone.
We'll just get the mic to
Thanks, Arie, for a very thought-provoking talk. Just hearing you speak again makes me think that looking at sentencing Aboriginal people differently from non-Aboriginal people and having that as a blanket rule, I'm thinking where an Aboriginal person has been disadvantaged through colonialism, that will play out in a whole range of on-the-ground mitigating factors. You know, parents who beat them up because the parents were unemployed a lot of the time or couldn't get rental housing, drug addiction. So the effects of colonialism actually get cashed out in particular circumstances. And they're taken as mitigating circumstances. So I'm wondering, I'm thinking, isn't the best approach then, instead of trying to square differential sentencing with the principle of equality, instead of trying to put a round hole in a square peg, why not just rely on those on-the-ground mitigating factors?
Well, the judges do, and I think when you said a blanket principle, that's what the High Court says. There is no blanket principle. All that Section 5 talks about is to statutorily recognise the systemic factors and then how they play out and leave it to the judge. I think that's the way it works, because those mitigating factors will play out in different ways. One is moral culpability. You know, he had an IQ of about 70, right on the borderline. The cognitive deficits, ADHD, all of that. Well, there are a lot of people who have ADHD, a lot of people who have cognitive deficit, and the law takes that into account in moral culpability, but also in the type of sanctions that might be applied. I think we have to be more creative, like the one I mentioned, the Aboriginal program, and to be more creative. I mean, what I think the challenge, and I've read a lot of this, and I'm really concerned, is, yes, we recognise the legacies of colonialism, we recognise intergenerational trauma, we recognise all of that. But that argument by these authors who I know is, we must break out of a generational cycle. Otherwise, in a sense, they and we become victims of a cycle which, if it's never ending, if we can never break out of those historical shackles, then it's doomed to failure. And I think that idea of strengths-based, it is possible to build or rebuild communities, is the way that we go. Otherwise, it's just, if you say, look, this is intergenerational and goes back to 1788, then I think we're doomed forever. We just can't we can recognise it, but I think the challenge is to break out of it. I don't know.
The question is, if we still have no mechanism for disruption, disrupting this, and that is the key, and that's why when you look at the technical stuff like valves, it's still on that almost atomistic individual level in a sense, because you need a broader structure and systemic change to do that. And that disruption, I talk to my son, even now he's a law student, where is that disruption? Where is the idea for that disruption? Where's the energy for it? And where's the political will?
So we tried. It was interesting. We tried. We say, oh, we're going to take these kids out and put them with white families. Well, we get stolen generations. I mean, lots of attempts to say, well, this is your background, we'll take you out of that. It was so counterproductive. I must say, because it's getting late in the evening, I'm very depressed. I mean, this is nearly 50 years since I wrote that. And we've had dozens of reports and dozens of attempts, and I've seen a lot of them, and the numbers are still high. And we don't, those Gladue reports are not going to make systemic, in individual cases, the sentences, the sanctions are there. But I've been watching this for decades. It's not getting better. Will the voice? I don't know. Will the self-determination? I don't know. But I have to say, looking at this, I'm pessimistic about what has happened. That's a terrible way to end, isn't it?
Well, we have another. Right.
Another question.
Another question from Alison Harcourt online. Yeah. Is the experience of ATSI women different to ATSI men? I'm not quite sure what she means by the experience, what it really refers to. Yeah.
Look, there are, as you see, the enormous overrepresentation of ATSI women in the system. 55% are on remand. Is experience different? I think some of the findings are that, yes, I mean, there's a lot more victimisation of ATSI women offenders who have been the victims of family violence. Many of them have particular substance abuse issues and the like. And so I think the cycle of victims becoming offenders is probably a bit stronger with the female offenders and with the males. And a lot of the reason that they're so overrepresented in the remand population is because there aren't the surroundings there to provide them with a stable environment, stable home, all the things that will allow a judge to grant bail. And apart from, we could have spent another whole session on the indignities of the Bail Act, which they're trying to reform. I think judges are locked into a bail act that requires people being locked up when they shouldn't be. So reform of the bail system, reform of the sentencing system. But, the judges are reluctant to do it. They don't want to do it. I know some of my best friends, but, they're faced with these dilemmas all the time. And I don't think they particularly want to lock up ATSI women either on remand or under sentence. But I think the pattern of sentences is also different, but I don't have the data on me now. One more question here.
In your experience with the Koori Court, has it been such that the tensions between clans make such a difference in the way the court deals with it? With my quite little, but working with children up on Cape York.
Oh, yeah.
And some other talks we've been to, you can't speak for my mob. And that if you're dealing with a Koori justice system and a court, how do they deal with that issue? Because it's a very strong one, and not being able to speak for another clan, and how on earth you can create justice and deal with people that are breaking the law.
Yeah.
In some way.
Sure. Look, I've had a lot of judges, imagine, who sit in the Koori Court. They've never raised that issue. I think they try to choose the elders who are closest in the community to the offender in particular areas. And in the city, you know, and there's a Koori courts in the city, it's not such a big issue because it's, I think, perhaps the identity with a particular group. Although I know families are very strong in the Indigenous community, certain families in Australia, in Victoria. I'm not sure about clans or tribes but, you know, I don't know what the appropriate language is, but there's certainly cultural groups that are different. But none of the judges has ever raised that as a point, because I think they're careful about choosing respected elders who will be accepted by the offender. Now, you've got to remember that for the Koori court, the offender has to plead guilty. If you want to fight the case, you go into the normal court. It's not there to determine whether you're innocent or not. You've got the right to do that, and then perhaps go into the Koori court. It's like the drug court and many others. Fight out the substantive issues if you want to in the ordinary court. This is dealing with what we do with you, the sentencing part. And so there'll be a discussion about appropriate people to sit as elders. So it hasn't been as big an issue as it may be up north.
Thank you, Arie. Well, I might just ask the final question. If you had supreme power and could wave your wand,
Yes.
what would be the two pieces of reform or the two changes that you would like to institute? I mean, I'm very much aware that we need broad-based change, structural change, and I'm hoping that we will have a cultural shift if we can get some movement about the voice, because I think that will be helpful. But you know, we've got a long way to go there. But if you had magic powers, what would you hope, or what would you particularly like to see
In sentencing?
Yes,
Yeah,
in this issue, yes, and in sentencing.
Well, as you see, as I said, you know, the sentencing responses are ameliorative. They're dealing with the symptoms. And I said a while ago that you're dealing, you know, like a doctor, you know, they're already over the cliff, and you want the preventive stuff. So in our crossover work, what we found was, if you've got the kids at the age of 10 or 12, and this is child protection, it's not the criminal stuff, child protection, which will continue. We followed the kids. There was about 80 of them, which we followed through. Had something like an 80 or 90% chance of ending up in the justice system.
Yeah.
And the Indigenous kids particularly. I mean, so, you know, early intervention, all those things where prevention is better than cure. In sentencing, I think the symbolic recognition in the Sentencing Act and more appropriate sanctions which are responsive to Indigenous people, that makes sense. Get rid of mandatory sentencing, for God's sake, and get rid of the parliamentary interference, as we're seeing yet again with parole, with Paul Denyer. You know, respect the public, but don't necessarily listen to everything they say.
Thank you. Well, thank you very much. You've been extremely generous and extremely helpful in helping us to understand this issue better. You know, the comparison with other countries and your breadth of experience, length of experience is invaluable.